Okay, good morning, everyone. Welcome to the Introduction to Mooting webinar organized by Zaid Ibrahim Co, ZICO, in collaboration with the Faculty of Law, University Technology Murad, UiTM, Shalom. The speaker that we have for you today is Ms. Amiza Murad from the Corporate and Government Advisory Unit of Zaid Ibrahim. A few things about Amiza. She's a well-known mooter. She's won, I think, almost all the prizes available for moot competitions nationally, including NAMCO, Law Asia, and JASEP. And then internationally, she represented Malaysia in JASEP 2018 in Washington, as well as being famous for putting Malaysia on a map in the foreign direct investment moots in 2016, when Malaysia, through UiTM, won the Asia Pacific rounds for the first time. And then Amiza and her team eventually made it into the global rounds and finished in third place behind Harvard Law School and Paris Bar. So she is a very accomplished mooter. Oh, I did forget one thing. Who am I? Right. My name is Irwin. I'm the head of the, oh God, I can't even remember my department now. No, just kidding. The head of the Advocacy and Dispute Resolution Unit at the Faculty of Law UiTM Shalom. So for many years, I've been the moot coach for UiTM. So now back to Amiza. She is here today to share with you some of her tips on how you should approach mooting, and maybe with some focus on mooting competitions. I shall now hand over the running of this webinar to Ms. Amiza Murad. Amiza, floor is yours.
Yeah.
Or
Hi,
cameras.
everyone. Yeah, thank you, Prof. Dr. Irwin, for the humble introduction. I'm very excited to share with you, with all of you today about mooting and my experiences that I've collected when I've mooted for UiTM. Can we go to the next slide? I think we'll just jump into the introduction. Next slide. Okay, so this is the outline of my presentation. Firstly, I'll be talking about the definition of mooting and why you should moot. Next, I will focus on the critical thinking skills, and then I will talk about the tips that you can use in your legal research. And thirdly, I will talk about how to write your memorial. And lastly, I will give you some tips on oral advocacy that I've collected throughout my mooting career. Can we go on to the next slide? All right, so what is mooting? When I brainstormed with my boss to do this webinar, I asked a bunch of you some questions on what you want to know about mooting. So some people actually did ask what is mooting because they don't know. So if you're new here and you don't know what mooting is, let me just briefly explain to you. So mooting is basically just an oral argument or presentation of a case or moot problem of two different parties that consists of the appellant or the respondent if it's an appellate court, or if it's in a tribunal, then it will be called as claimant and defendant. So basically, you'll have a judge judging the rounds, and you'll be needing to oppose to the arguments made by the other side. And the other thing that people ask is why should you join moot? I mean, law school is already stressful as it is, right? So a lot of people have actually debated on this, on whether mooting will actually be useful when you practice. I can tell you now, it is useful. Even if you don't decide to become even if you decide to not become a litigator, I think the benefits of the mooting weighs more than its cons. So firstly, we can see here that mooting actually, it can advance your, it can put you on a map to the employers in Malaysia. If you ask any mooters available in your firm, you know that in contrast or relatively, they are easily hired by employer because employers generally think that you know, mooters, they have experience in a lot of legal, they have a lot of experience on legal knowledge. Now secondly, the second benefit of why you should join mooting is because you can engage, you can debate on legal topic with interesting people. So I mean, it's not every day that you get to debate or on legal topics with judges, arbitrators, or lawyers. So mooting is really a platform if you're a legal junkie or if you just want to test out your legal knowledge, then mooting is definitely a place to go. Now, the last benefit that you should, on the reason why you should join mooting is because it can enhance your oral advocacy skills, your writing skills, and also your interpersonal skills. The thing about mooting is that you have, because even if you will, like I said, even if you decide not to go into litigation, as a corporate lawyer now, I can say that we do a lot of presentation. So my experiences in mooting has really helped me in that area. And in terms of writing, I think it has helped me in terms of when I write reports or even when I write a memoir or even when I write a written submission for my bosses. So yeah, I think that's the benefits. Can we move on to the next slide? And now we go to critical thinking skills. When I was searching for the definition of critical thinking skills, I can tell you now that there is not a lot of definition and all of the definitions are different. But the key themes about critical thinking is that there are always only three components. First, you need to gather information. Second, you need to analyze and evaluate the information and the legal knowledge that you have gathered. And third, you need to form a judgment. Now, a lot of times law students just think that, you know, in law school, some people just think that you can just you can just throw all the legal cases in the in exams. So that's not true, and that's not how we do it in mooting. In mooting, you have to be able to distinguish between cases, and you have to explain why that case would be applicable to you because you will be asked by the judge. Now, why is critical thinking skills important? Not just in mooting, but also in your career. Firstly, it can enhance your language and presentation skills. Now, because your ability to be critical on a text is really important. If I can give you an example, just a simple one. In statutes, you might notice that there's a phrase. This statutory, for example, the first example is this statutory interpretation may include, and there's another that it can also be phrased as this statutory interpretation means. So if you're a mooter or if you're a law student, you know that there's a stark difference between the word means and include. So that's one thing that you will learn when you join mooting. Now, secondly, it also promotes creativity. Now, the thing about mooting is that it's really a test of creativity actually, because all of the moot problems that you receive, and you will realize that these moot problems are really new issues. I can give you an example. JASEP, they have announced that next year's moot problem will be in regards to the issue of COVID-19. So we know that there has been no cases or that this is a global pandemic that has only happened this year. There has never been a global pandemic that is of this big before. So that's something that you can learn to argue when you join mooting. Now, thirdly, it is also important in the new knowledge economy. Now, when I say new knowledge economy, it means that in the legal context, we know that the legal world is always changing. It's a fast-paced world, really. So it's really important that you know how to think critically, because you will be expected to analyze the new cases, the new judgments and new statutes that have been issued by the Parliament. So I think these are the three benefits that you will learn in mooting in the part of critical thinking skills. Now, can we move on to the next slide, please? Now, a lot of people ask whether, the previous slide. Now, a lot of people ask whether critical thinking skills is if it's a skill or you're born with it. Now, the answer is no. A lot of research has been done to study on this topic, and it's just like dancing. A lot of people can dance, but the research has said that it really depends on practice. So the more that you practice, the better that you get in critical thinking. Next slide, please. Right. So how do you develop critical thinking skills, you may ask? Now, firstly, the first thing that you should do is not to assume. Now, this is really important. If you're a lawyer, when you read something, when you read a circular, you should always ask why was the law written as such, or who said it, or what was the context of the text that they have said. So the one tip that I can give you if you are confused is that you should always start with the 5W1H. You always have to ask why, what, where, how. So that will get you in the running of thinking thinking critically lah. So next, you need to read around the topic. Now, when you get a moot problem, for example, if you get a moot problem about robots, it's not enough that you check. If you're an international mooter or you've joined international mooting competition, you know that it's not enough to just read on the international conventions or the cases. It's really important that you know the ecosystem and that you know the political issues and the economic issues surrounding that topic. So that can really help to build your argument. And bear in mind that even in real life, judges are, these legal cases are actually stem from real life. So really these things, other perspective and not just legal perspective, they're very important in the act of formulation of argument. Now, thirdly, you should always debate the topic or the moot problem given to you in order to think critically of the topic or the legal precedent. Now, why do I say this? Is because if you're a lawyer or you're a law student, you know that when you read cases, there are different interpretation. Even in a judgment, we see that there's 5 judges. So it's really important that you grasp the opinion given by other people, so that it might be an opinion from your opponent. So that's something that you should think about, and for you to be able to rebut in your argument. That one I'll talk about it later. Now, fourthly, this is in connection to why you should debate with your former members or your friends about the legal question or moot problem given to you. Now, the reason why I ask that you debate is so that you can understand the two sides of every story. So it's really important that if you want to be an effective respondent, you need to know the reason or the mindset of your opponent. You need to know why she said that. You can't just rebut and not listen to them, because then it's a failure on your part to rebut on his point. So really, you have to understand each word given by your opponent. And if you want to go a step deeper, you have to, one tip that I can give you is that you have to check on all the sources that are given or uttered by your opponent. Now, next slide, please. Okay, so the next tip in developing your critical thinking skills, you need to use key phrase to demonstrate that you have thought critically of a legal matter. So one of the phrases that you can use is that, for example, I have evaluated both of these cases and I found that ... Or you can say an analysis of these legal cases indicates that ... So it really, you should, in your sentence, you should always say that you have done what and what have you found. All right. So the next one, you should always use all available information before reaching to a conclusion. Now, if you want to be a good mooter, you have to make sure that you have research on all the available resources given to you. So, and why I say this is because a lot of times mooters, they forget, maybe they forget to read a case and they just say as what they know. So it's really unacceptable, especially to the judge, especially if you've missed a very important case. So that's one thing that you should keep in mind. And lastly, when it comes to critical thinking skills, it's really simple. You should always use logic, and always avoid falling into the fallacy argument trap. So, okay, a lot of times, mooters think that they can just use cases. I mean, it's case, right? It's binding, right? So why should I even bother to think about why it was decided that way? Now, that's really wrong. So when it comes to mooting, logic is the most important thing when developing your argument. Now, this, so it's really important that you don't take the surface of what the law says, and you must always go deeper into the interpretation of the law or the commentary of the law. So, and the next step is also to ensure that you don't fall into any of the fallacies, or that you should always spot the fallacies given by your opponent. So, an example of fallacy is using pity. Sometimes you get a case and you just don't know because the law is against you. So, and you've used pity. I've used pity. So if you're my opponent, you should be able to point out to the court that, you know, that's a fallacy. You shouldn't do that because at the end of the day, every decision should be made on the basis of good law. So yeah, that's the last thing that you should keep in mind in developing your critical thinking skills. Now, next we go on to the legal research. Okay, we move on to the next slide. So yeah, guys, if you have any questions, just let me know in the Q&A. We'll try to answer it as after the presentation. Okay, so what is legal research? A legal research is basically a process of finding an answer to a legal problem and finding legal precedents to support your arguments. Why do you need to do a legal research? Firstly, it's because if you're a lawyer, your bread and butter is really just legal precedents on cases and statutes. So if you don't do your research, you will not be able to incorporate that into your arguments. Secondly, is that so that you can obtain complete knowledge about an issue. Like I've said just now, knowledge on legal is not enough. You need to research on the economical perspective and the political perspective of a legal issue. So that's one thing that the only way for you to do it is to do your legal research. There's no way to escape it. And thirdly, it is also to obtain persuasive judgment. Now, we know that at least for appellate courts, based on the stare decisis rule, only the same rank of courts will be applicable. Judgment of the same ranks of court or higher courts is applicable. So it's really important that you search for this level of judgment and judgment that is in your favor. And that can only be done through legal research. Now, lastly, it is to assist in solving complex legal problem. So the one tip that I've gotten from my senior before is to read the whole case. Now, the reason why I asked you to read the whole case is because once you've read, that the only way for you to analyze the thought process of the judge is to read the whole case and to understand where the judge is coming from. And that way, it will give you an idea on how to formulate your argument, especially if the subject matter of the legal issue is the same. All right? Okay, so how do you conduct a legal research? First, you need to identify the correct sources of law, and second, you need to use the correct legal method. Now, there is no correct legal method. I mean, essentially, it's up to you what's comfortable to you. But this is just something that I found that has worked for me. So I think we can go on to the next slide. Okay, next again. All right. So when we talk about So when we talk about Malaysian law, the sources of law available, I think you guys know this. It's written law and unwritten law. Written law is basically statutory statutes like federal constitution, state constitution, and any legislations such as acts or enactments. And lastly is subsidiary legislation. So subsidiary legislation can come from various forms, for example, regulation, order, rules, or regulation. Yeah. So the next source of law is unwritten law. We know that British common law and equity are unwritten law, but they are still binding, and the judicial precedent, the cases, judgments are all still considered unwritten law, and Sharia law is also unwritten law. Now, why I say that it's unwritten law is because previously, before it's codified, it was unwritten. So we classify that as unwritten. And lastly is customary law. Now we move on to the next source of law for public international law. Okay, so when we talk about public international law, bear in mind that every international moot competition has different source of law. So the ICJ statute will only be applicable mostly to the ICJ, but sometimes it's also quoted in international arbitration or IHL, depending on how you use it. So we know that the source of law is based on Article 38. You can refer to the International Convention. You can refer to international custom, provided that you can prove it. You can also refer to general principles of law recognized by civilized nation. And fourthly, you can refer to judicial decision and teachings of highly qualified publicists. So, okay, I just want to share you on the last bit. In order for you to, okay, this is just one tip that I got. In order for you to establish that a material is a teaching of highly qualified publicists, when I went to JESUP, the tip that was given to me is to ensure that you have, that you know that the author has written about 5 to 10 books. So that's really the standard that has been put by the judges at the time. So yeah, that's it. Okay, for those of you who don't know what ICJ is short for International Court of Justice, which is also known as the World Court, and is also one of the 6 principal organs of United Nations. Now, if you want me to explain more on international sources of international law, feel free to ask in the comment box. Okay, now we move on to legal research method. Okay, this one I got from LexisNexis, but like I said, there's no right and wrong in doing your legal research. So this is just for you to, maybe this is just a start. If you're new, this is just a start. Okay, but this is also what I do. So when I get my, when I get my moot problem, the first thing I will do is, of course, I will read it. and then I would determine what's the rule that is governing this, that governs the moot problem. So for example, if it's an arbitration case, I would need to determine whether it's set in Malaysia. So if it's set in Malaysia, the probability of it being held in AIAC is very strong. So that's the first thing that I would identify. Then I would know that the rules that I would have to use is the AIAC rules. Now, and then I will determine which party that I'll be representing. If I'll be representing the appellant, then I'll make sure that I'll make sure that I gather the information that supports the appellant's case. So one tip that I can give to you is to write the facts according to the timeline. And this will enable you to really look into the legal issues and the elements that you can tackle in your legal research. Okay? So, okay, we start at the bottom of the pyramid. Always start with secondary authority. Always start with secondary authority. Now, why do I say this? Is because primary authorities are a lot, and sometimes when you don't know about the topic, you be like a headless chicken, you know, going into primary authorities and reading just everything is really not worth it, and it's a waste of time. So secondary authorities include commentaries, practice guides, news, law reviews, and textbooks. So always go into that first, and then you can move on to the primary authority. So once you've gotten the secondary sources, the secondary authority, write what are the cases that are used in the textbook or the article surrounding your legal issue. So once you've written that, you have to go on to the primary authority and look, and you have to read the primary authority, and then you have to do Shaffer's validation. So I think we move on to the next slide for me to explain to you what is Shaffer's validation. Can we move on to the next slide? Right. So like I've said, always start with secondary sources and then move on to primary sources. And then you have to, this is a term by LexisNexis. I believe it's because of a tool that they have. So it's called Shaffer Guiding. So this principle is basically just a principle to check whether the case has been overturned or it has been reaffirmed. And the purpose of doing this activity is to ensure that the law is still good law. Yeah. So the last part is to repeat back the cycle. So the reason why you have to do this is because as and when you moot, you will realize that you may have forgotten something, or that the case laws may have been developed, or that the circumstances may have changed due to the clarifications given to you. So it's always important to research, and my tip is to never stop researching until the end of competition. All right, so we move on to the next slide. Now, on the tips to conduct an effective legal research, first, you need to know what is your legal topic and area of research. Now, the law is as vast as the ocean. Knowing where to start it should be your first step. So after you've determined the topic of your research, then you have to narrow down and identify the area of research. Now, an example that I can give you, maybe the topic of research is contract law, right? So first you determine, that's the first base that you determine. So then you go on, what about contract law that you need to research on? Maybe you should research on the parties' duties. And once you realize that the parties' duties have been breached, what can then you research on? Then maybe you go on to breach of contractual duties and so on and so forth. So think of it as a funnel method. Always go to the base and move on to the specific ones. All right, the next one is to formulate legal issues and legal questions. Now, I believe Moot Problem has already determined the legal issues for you. But if you've joined Law Asia, you would know that sometimes they don't actually give you the legal issues. So you need to know, this one you need to discuss with your team members on what the legal issues is. the legal issues are. So if you can only determine the legal issues by reading the problem critically with your team member. So yeah, the next one is using broad approach. For example, like I've said, the broad approach is basically reading the secondary sources first. And once you've gotten the authorities from the secondary sources, then you can move on to the primary sources. And yeah, because once you have an idea from the secondary sources, then you can go on to the primary sources lah. So next one is narrow approach. Narrow approach is obviously the opposite of broad approach. Narrow approach means that you look into the case laws first, and then you look at the referred headline, and you refer to the cases. You read the cases that are on the headline. That are on the cited case section. All right. So yeah, that's how you conduct an effective research. Now let's move on to the memorial writing skills. Can we move on to the next slide, please? Next. Okay, what is memorial? Memorial, I have to be honest with you, this is not my favorite part of mooting, but it has to be done. So a memorial is a written submission where mooters would have the opportunity to put all of his argument into the research. So memorial is actually not a legal article. Don't just put every single law that you know into your memorial. So the purpose of memorial is really to articulate your legal analysis in written form. It's basically just another form of your oral submission, but yeah, it's just in written form. So for appellant or claimant, your job is to basically explain your position and the facts and what wrongs that were caused by the respondent and what damages that you should receive. So for the respondent, your submission should also contain of facts, your position, and why the appellant should not win the appeal or why the appellant is wrong in their judgment. All right, next slide, please. Okay, so this is just the content of a memorial. What's a good cover page? You should always make sure that it's consistent, that your font is consistent. You should always have a theme code, the name of your moot court, always have that, and the parties. So if you want to be extra in your memorial writing, always put a cover page. Some teams, I realize, they print the cover page in color pages. So that's something that you can do. I believe that it's aesthetic, and it's always good to have that. So the next one is table of content. This is basically, it just lists the content in your memorial. It basically just lists what your arguments are in written form. In a brief form. The next one is table of abbreviation. So table of abbreviation is not typically needed in local mooting competitions, I believe, but once you go further, you'll realize that it's important because of the Latin words used in the legal cases. Next is index of authorities. This is basically just authorities that you have used. Now, bear in mind that the index of authorities need not be, it's always impressive to have a lot of authorities, but you should always make sure that there's a reason for the authorities put in the index. And you might not know this, but judges actually do check. And especially if you go to JASEP, into international competition, maybe this. Bear in mind that they do check the relevance of this. Next is statement of jurisdiction. So statement of jurisdiction is particularly important if you do Law Asia where the jurisdiction is disputed. So you might want to write your jurisdiction, your statement of jurisdiction, and your argument of why it should be maybe Malaysian law or Singaporean law. Next is statement of facts. Statement of facts actually it should be short, and I think the best way to do this is to highlight your argument, the facts that is supporting your argument. So that's one. And then you go on to the issues raised. Basically, issues raised is just the issue that you have to tackle in the moot problem. Next is summary of arguments. Summary of arguments is just, well, an effective summary of argument means that once the judges have read the summary of arguments, you should always, they need to be able to understand thoroughly what your submission, your written submission will be. Next is arguments. Arguments contains of detailed arguments of the issue raised. Your arguments should be, one tip that I can give you is to not make it repetitive. So once you have once you have a proposition, try to find 2 or 3 sources to put it in your index, to put in your citation, because I believe that actually carries marks. And lastly is prayer for relief. Prayer for relief is just basically what you want to ask from the tribunal or the court. So there's really no need to, it's really not that complicated. For as long as you have a clear idea of what your argument will be, then you just have to make sure that the wording used is formal language, and you have to make sure that always check your grammar. What I did when, at least what my team did, was that we would, once we've written a memorial, we would go through one by one, every line with everyone. So we will print, if we have like 4, maybe 5 people in our team, including our coach, what we'll do is that we'll print for everyone and we'll read it one by one, and everyone will give their opinion on the sentence used. So if there's a grammar mistake, we'll all correct it together. Now, you don't have to do that, but I believe that that's one way for you to make sure that your memorial is good, and maybe this practice also helps you to address all of the issues that you may not have addressed, because as you have your whole team together, then maybe your opponent, your team member opponent, can raise the issue where you have not written in your memorial. All right, next. Okay, what makes a good memorial? A good memorial consists of application and explanation of the facts. Like I've said, not all facts have to be addressed, but you do have to make sure that you explain the facts that you use, and that you apply only relevant facts. And second is recognition of issues and structure of arguments. Now, recognition of issues is very simple, because they do actually put it in the moot problem. But when it comes to structure of arguments, make sure that you do use for example, if you use the A in your main argument, then maybe if you want to go to another level, maybe use number 1, and the next level maybe use A. So there should always be like stages of your structure of argument. Next is quality legal analysis. So like, to be able to write a good memorial is really a good research, guys. There's really no way around it. So this is particularly an important factor that is put in almost all of the written submission score sheet that I've seen. So next one is overall presentation. Like I've said, make sure that your language is formal, make sure that your structure is on point, your format follows the competition format, and citation. So if you're new to mooting, bear in mind that every moot competition would have different format. So make sure that you adhere to the format to be safe. Now next, we move on to the last part, which is my favorite part, which is oral advocacy. So next, what is oral advocacy? Oral advocacy is basically an oral presentation of a party's position and the reasoning behind it before an appellate court or a tribunal, depending on what type of moot that you guys do. So why is an oral advocacy important? Now you may even ask me, why do I need to know why? I mean, it's a moot competition. Of course you need to do oral submission, right? So I mean, this is not the case in real life. In real life, practically, I know that once you have written your written submission, you've given your written submission to the judge, sometimes the judge may not even ask you to give an oral submission. But let me just tell you why it's important. So basically, the importance of it is a chance to further explain to the judge your most important arguments. So because the judge that come to the competition may not have read your written submission, or maybe if they have and they have analyzed maybe that this is wrong, this is your time to show or to persuade the judge why your arguments are right. So yeah, when I say that the judge has analyzed and would want to point out to you your mistakes, maybe this will come in a form of question and answers. All right. So I've just gotten a quote from a judge. She's a moot court judge. She said that advocacy is one of the more difficult art, but one of the most useful. And it's true. Like I said, advocacy is really a game of creativity. So there's really no right and wrong. For as long as you're confident and your arguments are logical, you'll be fine. So next is how to prepare for oral submission. So I've divided this into 3 stages: before, during, and after. And why I put after is because your oral skills should not be honed by just one session. So you can always learn you can always improve more on your oral skills after every session. So let's just go to the points one by one. Okay, so before, what you should do, we know this, that you need to research, you need to practice, and you need to repeat. Now, what are the types of practice that you can use? One thing that I used when I first started mooting is that I practice in front of a mirror. This tip was actually given to me by my mother, who was a lawyer. So I mean, if this has worked for a long time, I think you guys should give it a try. So secondly, you should always record yourself. Now, when I did my mooting, when I first started recording my submission, I realized that I had a lot of gaps, and I realized that I would always look up when I'm thinking something. So that made me really aware of my body, my bodily movements. So that's one thing that you can do to improve on your oral skills. And then you just need to repeat. The oral skills is just repetition. There's one person who asked me, Amiza, how do you deal with anxiety? And there's really, the only way to deal with it is just to practice. You know, to practice in front of, maybe just try to practice in front of your friend, or if you really cannot control your anxiety, maybe try to practice. One tip that was given by my senior is to hold the pen. But make sure when you hold the pen, you put it on at the bottom, and make sure that the judge does not see it. Yeah, that's a few tips to help you if you have anxiety. Let me know if you want to know more on how I deal with anxiety. Next is to avoid using scripts and to use bullet points instead. Now, I see a lot of mooters use scripts, and this is really not the best way to advance your oral submission. It's okay if it's your first time. It's okay if it's your first practice, but over time, you really need to reduce your script into bullet points. So what I usually do is that I would just put my argument. I'll just put like what's my premise, and then I'll put what the authorities I'm going to use in full citation. So if I have one statute, I'll put it there. If I have 2 statutes, I'll put it there. And I won't even put the facts of the case in my so-called script. And that's only because why I asked you to do this is because it's to ensure that you have flexibility when judges ask you questions. When you have scripts, it's really, for me at least, I would tend to go on to look at my script and to see where the answers are in my script. So that's really not effective, especially when you want to appear to the judge that you know your case. So if you already have the case that or the authorities that you want to use as bullet points, you can always talk your way out to the judge, okay? But that comes also with memorizing the legal principles and the cases that you use. Next is to research on the authorities used by your opponents. My experience with this is because in one of my moot competition, the opponent actually cited the law wrongly, and I know that my opponent knew about this, but I guess it's just because he was anxious about it. Maybe he was nervous, but that's why you need to research on all of the authorities used by your opponents. And the reason why I asked you to do this is to really, like I said, you have to really understand where your opponent is coming from. Okay, next. Okay, I've already said this, record yourself. Next is read the competition rules. I've already mentioned this. Okay, the next one is know your panel. This is so important, and I think when I remember doing this first time, and my teammate was like, "Wait, why are you so kiasu, right?" But it's actually really important to know your judges, and not just that. Okay, the tip to do this is when you receive the moot booklet, you'll actually know who your judge is gonna be, and even if you don't know who your judge is, if you can, maybe you can ask the bailiff, but if you can't, that's fine, right? That's nothing that you can do. So the reason why you need to know your panel is because most of the time when the judges are invited to the moot competition, it's because of their expertise. So for example, if your moot problem is about the federal constitution, and they call Prof Shat. So we know that Prof Shat is the father of constitution. I mean, he taught me. So when I did my Tun Sufyan competition, and I knew that he was going to be my judge, of course, as a mooter, you would automatically focus more on the things that he has maybe that he has read or that he has written. So and actually, in my experience, it benefited me, because when I did that in my competition, I actually cited the case, and he was like, I remember him telling me that I remember him asking me like, is that even right? And because I've already read the case, I could tell him that it's his judgment, and if he does not accept it, then he will go against his word. But that's only because it was a coincidence. But if you know who your judges are, you should always read about them, and always ask around how the judges are. If the judge is a quiet type, then you may need to do something for the judge to be engaging in your oral submission. And the last one is to reread your memorial. Oftentimes, when you do trainings, you already forget what you've write in your memorial, right? But during the moot competition, the first thing that the judge will do is to look into your memorial. So always know what you've written in your memorial, just in case the judge asks. So during oral submission, how do you prepare? Well, how do you do it? Actually, you should always be polite. Always address the judge politely, like Yang Arif, my lord, Mr. Arbitrator, Madam President. Always know. That's where, yeah, I think this is very basic. Next is to put the most important arguments first. A lot of mooters make the mistake of putting the argument because maybe it was firstly addressed in the moot problem, and they dare not put the most important arguments in their oral submission. Now, this is actually wrong. I've learned this. I think I really incorporated this practice into my mooting skills in my 3rd year of mooting. So I think if you want to, that's something that you can learn from me. And next is to focus why you are right, not why your opponent is wrong. So don't, the thing about mooting is a gentleman game. You're not going against your opponent. Your opponent is always the judge. So if the judge, so your role as a mooter is really to address the questions by the judge. And also, next is to also listen to the type of questions asked by the judge to your opponent. Sometimes the judges already have in mind what they think the case should be. So if you want to know what type of questions or what are the issues that they are most concerned with, always listen to the questions that they ask. And if your opponent could not, maybe your opponent could not answer the question, so use it to your advantage and point to the judge and say, and incorporate it into your submission so that you look good in front of the judge. And lastly, know when to concede. If you have a tough judge, if your judge does not seem to buy your argument, just concede. Because I know it's a hard thing to do, but there's really no point arguing for a long time with the judge on something that the judge already thinks you're wrong. So in those extreme cases, then the best way to deal with it is to concede your point. Now, last, after oral submission or after every session, what should you do? You should always ask for feedback. Now, this is something that this is common. I mean, I think it's really important to ask for feedback because every judges have their own concerns and every judges come from different backgrounds. So if you really want to know, how to tackle the judge, maybe if the judge is a lawyer from a big firm, then you want to know his standards or his way of thinking. So you can only know this once you ask feedback from the judge. And next is to write your opponent's questions. Now, what we do is that we would actually write what are the questions asked to our opponents, and we would actually give it to your teammate. You can do this, but bear in mind that you have to bear in mind some ethical issues. There are ethic problems with this because some mooters actually bring in almost all of like 10 people in the room just to write down questions. Now, I think to me this is ethically wrong, but but it is one advice that I can give to you if you want to improve in the next submission or the next session. Next is to go through the least persuasive arguments, the arguments that the judges didn't buy in the previous round. So always revise it. If you know that this is not a sound argument and if it's not accepted by the judge, always think of why. But bear in mind, you don't really have. Sometimes it's just the judge. So don't be scared. Just discuss about it again with your moot coach or your teammates. And lastly is connect with the judge. Now, connecting with the judge is important. Because like I said, judges come from all walks of life. They might be your lecturers, they might be they might be a senior lawyer, they might be a partner, they might be a real judge or an arbitrator. So this goes beyond mooting. This would actually help you in your prospect of getting a job next time. So if they remember you, most likely than not, if they remember you and they've seen how you talk, most likely than not, then they would actually hire you, or you would have a higher chance of getting employed. Okay. So the next one is structure of oral argument. We have introduction, signpost, facts, issues, conclusion, and rebuttal. Let's go to this very quickly. Introduction, begin with may it please this honorable court, or if it pleases the court. But if it's an arbitration setting, you don't actually have to say this. What I do is I say greetings and I just start with my submission. Next is to introduce your team members and your opponents as your learned friends. Now, teammates, when your first counsel introduce you, always make sure that you stand up because this actually leaves a big impact to the judges. Next, you should state who you'll be acting for, and then tell the judge your points. And second last thing is to mention the time that you need and the time that your teammate needs. And lastly is, if you're a first counsel, then tell the statement of facts. So for roadmap is very important. Signposts are very important. Why signpost is important is to ensure that the judges are able to follow your argument. Most of the time when you give your post or your roadmap, the judges will actually write on a piece of paper. So it also teaches the judge to ask questions at appropriate time. Now this is just an example of how you should do your roadmap. That you can have a read. I think we'll make this presentation available to you. Now the facts. Can we move on to the facts? Yeah. So okay, what's the facts, right? Like I said, can we move on to the facts? Can we go? Yeah. So what's facts? Facts is basically information that supports your team's legal argument. So who should do it? Who should give your facts? It should always be the first counsel. Like I said, but if the first counsel of the appellant has given an error in the facts, then the first counsel of the respondent should always step in and correct the facts so that the judges don't have a one-sided view of the moot problem. Now, how should you do it? The facts should always be between 30 seconds to 1 minute. Yeah, it really depends on how much facts that you need to address and how long that you think you can allocate for it. Now, for facts during submission, let's just go through on how to address the judge's attention to the facts if you need to. So always request politely and always mention the page number and the paragraph number. One tip that I can give you is that always have a piece of paper of all the facts that you will use. Always write down the facts and then write down the page and paragraph number. This is one, in my previous competition, the only page or the only documents that I'll bring is only these two documents, which is one, maybe my arguments, another one is my facts. So that can really help you. Next, you should always give the judges time to turn to the page. I think if you're nervous, I see a lot of mistakes with mooters being nervous and they just go on submitting without waiting for the judge. And sometimes judges actually penalize you on this. So be very careful on this. And how to quote facts, you can either quote it in verbatim or paraphrase. Now issues, can we go on to the next one? So issues, so how do you deal with legal issues? This stems from your legal research. Once you've gotten the statutes, the precedents, you should always distinguish and see how it applies to your case, and then use the facts that is applicable to the legal issue and state why the judge should decide in your favor or address any loopholes or logical holes in your opponent's submission. So it's really, to me, it's not rocket science. It's just how you address the legal problem that makes a difference. So next, the last part of your oral submission is your conclusion. So always indicate that you are concluding, and if you're a first speaker, just conclude your argument. Your conclusion should always be short and straightforward. And yeah, you should always conclude your conclusion. Now, what I mean by this is that you should always say that you're done with your conclusion and you'll pass the floor to the second speaker. So for the second speaker, how to conclude, you should always do what the first speaker does, except for the passing of the floor, and you should always state your prayer for relief and end your submission with a powerful statement. Next is rebuttal. Okay, what is rebuttal? Rebuttal is basically the last argument and it's a direct answer to the other party's argument. So when is it done? It's usually done at the end of every submission. And how should you do it? You should summarize the most vulnerable arguments made by the opponent and state why the argument used is wrong. Next. Okay, this I think is my last section for my presentation, how to deal with judges. So there are a variety of judges that you will meet in your mooting competition. One is the quiet judge. You should always be careful with this type of judge because essentially you will be graded on your ability to answer questions. And with this quiet judge, he may not ask you a lot of questions. So you should always try to engage with him. Secondly, the bored judge. I've experienced this personally. I've gotten a judge who actually played with her phone while I was submitting. Now, I think this is just a tactic to scare me off. I don't know. But if you do encounter this type of judge, always vary your tone and your pace and make your speech interesting and make eye contact. The next one is the confused judge. The confused judge is basically the one who could not follow your arguments from the start. So if you notice that the judge is confused, always ask if the judge is doing okay. I think the judge will appreciate that. Now, can we move on to the last slide? All right, so next is the mean judge. You might encounter this, and I think this is just a tactic used by judges because you just want to test whether you can handle a mean person, basically. So how to handle this is to stay calm and be polite and don't take the comments personally. And if the mean judge is not agreeable to your arguments, just rephrase your speech, okay? Yeah, the next one is the questioner. So this type of judge is the judge who will always ask questions, even when you want to submit. So always know when to stop the judge, but be polite about it. And if you don't understand any of the questions given by the judge, always ask for clarification and deal with the questions. Make sure you do, because for a questioner judge, this is where he will give you the most marks. The last one is multiple judges. So when you have multiple judges, you have to always make sure you give the same attention to them. Because at the end of the day, judges are humans. They want to know why, they want attention, basically. So always get all of them involved and always maintain eye contact with all of them. So yeah, I think we can move on to the next slide. I think we're done. Yeah, we're at 11:03. So if there's any questions, maybe, yeah, we can answer it now.
Okay. Can I ask you a few questions, Amiza?
Yeah, sure.
Okay. We have questions from the attendees of the seminar.
Yeah.
I'm going to start with the first one. The first question posted by a person called Anonymous.
Okay.
Can you tell more on how you deal with your anxiety during oral submission? I think they're interested in knowing how to deal with nervousness. Okay,
the way to do it is, how I actually do have anxiety. So when I first started mooting, my voice would actually shake. So how I do it is that what I do is that I pray. I don't know if that will help you. So that actually helped to ease me. And I think preparation before oral submission is also important. I exercise, but during the competition or during the oral submission, how I prep for it is that I will record myself. And if I see that my voice is shaky, I try to cover it up. So I try to fake it until, I just fake it until I make it. If you do really have terrible anxiety issue, I recommend that you record yourself and see where your voice shakes. Listen to yourself and see where your voice shakes. And I think the last tip that I can give you is to do visualization. This works. Maybe this works for me. What I do is that I will visualize the judge ending my speech with judges happy with my oral submission. Yeah, I hope that helps. But if you have any specific questions or any specific problems that you want to ask me, or you want to, like, what your symptoms are, you can always ask me directly. Yeah.
Okay, thank you for answering that, Amiza. Perhaps there's one more thing I can add to that,
Yeah.
Like in UiTM, right, our training revolves around a lot of question and answer sessions, So the more questions you get to answer, the more comfortable you become with providing the answers, the better prepared you are to answer those questions. And usually this becomes muscle memory by the time you go into competitions. So you will probably get a question that you have encountered before during the
Right.
competition, so something you've done in training. So, you can just pull that out of the hat and use it as and when needed. Most people think that, mooting is this spontaneous affair, where you just answer questions like on the fly. Actually, it's not. There's a lot of preparation that goes into it, a lot of careful research, a lot of careful preparation, and the answers that are given, right, are carefully crafted as well. So you give an answer that is accurate and also very convincing, tailored to the particular way in which the judge poses that question. Right. Can I ask the second question for you, Miza? This
Yeah,
is also
sure.
from another person called Anonymous.
Yep.
Now, this person says, Amiza, any tips on how to avoid using filler words when presenting?
Okay. How I do this? Well, I'm actually, to be very honest with you, I'm not I have problem with this as well, and I think it's by having someone telling you that you are using filler words when you're presenting. So what I do is that if I notice that I'm using the same words over and over again, I'll pause and I'll pause and then I'll continue with my sentence. Or if that does not work, then maybe what I'll do is that I'll practice. If I use the same words again and again, I'll restart my sentence. So that will disrupt your sorry, I see I'm using again. So that will disrupt your structure of your wording structure or your sentence structure. Sorry. I don't know if maybe Prof, you have any other ideas or any tips?
Okay, Miza, just to add a little to what you said earlier,
Yeah.
I don't think you can completely eliminate filler words because that's a very human thing to do. So maybe one thing to do is just embrace it first and then work on reducing the number of times when you have to use it. Filler words are actually quite useful. They provide an opportunity for you to gather your thoughts, think about a matter, and then proceed with actually what you want to say. I suppose the most effective way you can sort of cut down on it is to speak much, much slower. Because while you're speaking slowly, you get an opportunity to formulate your words. You tend to go into filler words when words come out of your mouth like a machine gun, and your brain
Yeah.
just cannot catch up, with the speed at which your mouth is trying to spew words out. Okay, I will then move on, if it's okay with you, to the next question by our anonymous number 3.
All
Amiza,
right.
how do you determine whether a fact is crucial or not? Should you include minute details as well, like the value of the damage done?
Okay. How do you determine whether a fact is crucial? A fact is crucial if your argument depends on it. So if your argument depends, if the value of the damage done would actually make an impact to your argument, then it is crucial. Yeah, that's
Okay,
my tip.
Yeah. Okay, that's interesting. Maybe I can also add something to that.
Yeah.
I think the facts which you should harp upon, right, is the one which, you know, has some sort of maybe impact or shock value as well. Like
Yeah.
in this year's JASSP, right, the question was about an AI operating some sort of a wall, which actually had a graded response system. But the ultimate response that the wall could have, right, is actually using a 50 caliber machine gun, you know, and that was probably the only problem with the wall. So, you know, if you are the counsel, you know, which has all the arguments against you, and that's the only thing you can use. So perhaps that little piece of fact is something you can harp on, you know? Because a 50 caliber machine gun, right, is actually an anti-material weapon, and it's actually not made to, well, it's made to kill humans, but you'll be blown to bits, you know, but it's actually made to penetrate walls and things that you hide behind, like an engine block, etc. You know? So that's probably the only thing that you could harp on. So it's one particular fact which could actually make the other side look really bad as well, despite of all the other things in your favor. Okay, I will move on to our first identified person, a person called Imran. Right. If you
Okay.
encounter a quiet judge, do you actually engage with them and ensure that they follow your arguments? Do you ask them questions? Can you maybe provide an example? Thank you in advance. Very polite man, Imran.
Yeah. So okay, it's quite tricky to deal with a quiet judge. I mean, there's a reason why. There are many reasons why a judge could be quiet. Sometimes the judge just want to hear the opinion or the questions given by other judges. So, but I think the type of questions you should never ask a judge whether the judge. this, this is one thing that I learned. You should never ask the judge multiple times whether he or she has any question for you, because a lot of judges, they tend to snap when asked with that kind of question. So maybe one way to formulate your question is to first say the principle and say whether the judge would want you to elaborate on the facts or the principle of the case. Yeah, so that's one way to do it.
Okay, thank you, Miza. Can I move on to the next question?
Yes.
This is from a person called Anis. She says, may I know how to engage with a judge?
Okay.
I suppose the question was directed in the form of, you know, a question when you're making a submission, not an engagement for a wedding.
Right. So
Yeah.
okay, the best way to engage with the judge is to maintain eye contact. Now that can only happen if you do not have scripts with you. The second way is to make sure to vary your intonation. So I mean, there are some mooters that actually can engage with the judge by not varying their intonation, but that can only work if you are very clear and you are you're very clear in your thoughts and in your speech. Yeah, so that's for engagement with the judge. Typically that's just all I do. I think the most important thing is to engage eye contact, to make eye contact. Yeah.
Okay, thank you for that explanation, Miza. The next question comes from Anonymous. Amiza, can you further explain how to do rebuttal more effectively?
Okay, so the thing about rebuttal is that you would have to listen. You'll be given lesser time to prepare than a rebuttal, right? So what I do is that you have to first write the rebuttal given by your opponent, and then but the thing is that you have to bear in mind that you don't actually have to rebut everything. What you can do first is to arrange your rebuttal into the most vulnerable argument, with the rank of first, the most vulnerable argument made by your opponent. So That's one way. The second thing that you should do is you should always know the type of you should always know the principles of the case, and just think on your feet, and always make sure that you have good communication with your teammates so that you can respond to the rebuttal effectively. Yep.
Okay, thank you, Miza. There is actually another question, but I thought I saw it under the new live event Q&A, but I can't seem to see it here. Okay, yes, it's here. Another question from Anonymous. Any tips on how to train your thoughts when you suddenly go blank during the presentation?
Okay, the way to do this, okay, how do you train your thoughts when you suddenly go blank during presentation? I think if you go blank, there's the only way to do it is to ask for a moment from the judge. And I think if you do it politely, this will not have any effect on the scores, on your scores. And the second thing to do is to always have, like I said, if I do go blank, I'll always go back to my points, my first premise. So always have your arguments in bullet points. Thirdly, you need to make sure that you have a good teammate that can actually assist you when you do go blank. So if you do go blank, maybe as your teammate, I would give you maybe the answers to the questions asked by the judge. Yeah, that's my tips to train your thoughts. Yeah, but if it's a prolonged problem, if it's a problem that you have consistently, then probably you will need more practice. I think maybe that's because maybe you didn't have enough practice, or maybe it could also come from anxiety. So you really need to determine whether which one is it. If it's because of your anxiety, then I think that you should go back to the root problem and manage your anxiety first. Yeah, that's all from me.
Okay. Yeah. Okay, thank you, Miza.
Yeah.
Maybe I can just add a little here. Sometimes when you go blank, right, and you are asked or faced with a particularly difficult question, and you don't have the answer for it. If you remember, right, this is what I advise all of you to say. Your Excellency, we have researched thoroughly on that point, but the research that we've conducted does not provide a direct answer on that. However, what we have found out is this. So you can go back to your point, it's sort of a license to go back, to your original submission before you got diverted away from it.
Yeah.
But it cannot be done too often because they will see right through you. Yeah, usually when you're faced with something like that, it means that, not enough thinking has gone on behind the scenes, because this should have come up in your research and in your practice sessions.
Yep.
Right.
I think we have one last question.
Okay, one last one from Anonymous again. How do you deal with opponents who have issues with delivering their speech, like they mumble?
Okay, so you really you really can't change your opponent, so it's really an unfortunate thing if you do get that kind of opponent, because then it will cause you a problem. But if they mumble, and there are two situations that may happen in this case. One, the judge will ask them to repeat again. Second, the judge will be quiet. So if the judge asks, then the opportunity that you can take here is to listen again and to take the conclusion made by the judge. Because maybe the judge will say, oh, so your argument is this. So maybe, and take that as an opportunity to put and address it in your argument. yeah, secondly, if you get a quiet judge, the best way for you to deal with it is to read their memorial quickly and just address that in your argument. If the judge does not ask, it's more likely that they actually do not understand and they don't want to ask. So I don't think this would be detrimental to you if you do use this technique. Yeah, that's all from me.
Okay. Thank you, Miza. One more question from Anonymous.
Okay,
How
sure.
do you address rebuttals that do not respond to your points? Do you acknowledge this in your speech?
Right. So if yes, the short answer is yes. You have to acknowledge this in your speech or your rebuttal. I think judges are aware if a rebuttal is actually does not correspond with the main argument. So to really flaunt this and to get an extra points, I think you should address it in your speech. Yep. I think we've exceeded time.
Yeah. Yeah,
So,
I think we've exceeded time a little as well.
yeah.
But maybe to wrap things up today, right? Can we go through, like each area that you've done? Maybe just one tip for each area, which if you have to practice something, that's what you do. Can we start with critical thinking first? So the best tip you can give, like Amiza Murad's 101 on critical thinking, the most important thing.
Yeah, so my best tip on critical thinking is to always be one step ahead of your opponent. So this I relate to critical thinking is because the thing about critical thinking is that it relates to preparation. So if you know that your opponent has a better case than you, then always be one step ahead and research on why that case should not be used. And it's a cycle really. So to me, it's a race, and it's a race that you should always participate in. So for legal research, the best way my tip is to get an expert. Talk about the legal issue with the expert. And thirdly, for memorial writing, is my one best tip is to go through one by one, one sentence at a time with your teammates to ensure that there are no grammar mistakes made, or to ensure that no arguments are left unanswered. And lastly, for oral advocacy, my best tip is to practice invitation, practice different styles, practice to different people. So I don't know if you know this, but what we do is that we usually would call people from outside. We don't. You can call your seniors, but you can also make an extra effort and get lawyers to listen to your arguments. So I think that's one that could really help to improve your not just your oral advocacy, but also it can also help to develop your argument. Yep. So that's all from me.
Okay, I think maybe just to wrap things up at the end, let me just share with you why mooting is so important as part of legal education, and why you should do it at some point in your legal education. Students at UiTM are lucky because mooting is a compulsory subject in part 4. And in addition to that, students that come in part 1 and part 2, they go through something called a moot module. So they start mooting very early on before doing, the compulsory mooting in part 4. I think I'd like to thank Miza for this, because you contributed to a workshop that we conducted earlier in the semester for this, right? And when employers contact me and they're looking for, recruits, either champions or people whom they want to hire for their firms, the top of the list will be, which mooters do you have first that you can recommend to us? it's always the mooters, that are requested by law firms. And there's a reason for this. Firstly, because your critical thinking skills are usually at an elevated level, much better than the rest. Your legal research skills are second to none. In fact, I can still remember one former Jasper, right, who was an intern at a law firm. The senior partner actually cried when she left because he said that now we don't have anyone who can do research this well for us anymore. And thirdly, your writing skills have also improved tremendously as a result of, memorial preparation. And then well, I need not say about advocacy because this is a strong point, I think, of UiTM. Usually you do very well in the advocacy part of the competition. So all of this actually provides a package which is very attractive for employers. Now, if you have won JASEP, or if you're runner-up, or you have taken part in JASEP, that even adds to your, employability. So I think in tough times like this, where places for chambering and places for jobs are going to be limited, this is what's going to separate you from the rest of the other applicants. So if you have the opportunity, please go and sign up for the moot competition, and get involved in the practice of all these skills which are necessary for your legal career later on. So yeah, anything else you want to add, Miza, before we wrap up the session?
No, I just want to say thank you to all of you who have stayed, who have watched this webinar. I hope this is useful to you. If you do have any questions, feel free to reach out to me. I am available on social media. Don't be afraid to just drop me a message. Yeah, I'll be sure to answer your questions.
Do you want to give them your Twitter address?
Yeah, my Twitter address is just Amiza Murad, and my Instagram is just amiza.murad. If you want me to even come and train you, I think I'd be more than delighted to do so. Yep.
Okay, thank you so much, Miza. I think before we end today's session, we will have to thank a couple of people who have been tremendous behind the scenes. The audience cannot really see them, but without them, the whole webinar thing just will not work. I think we have to give thanks firstly to Miss So Wei Wei. Wei Wei, can you reveal yourself, please, so we can all give you a round of applause?
No, it's okay.
Okay, you still don't want to activate your camera. Okay.
No, thank you to all the attendees.
Yeah, thank you, Wei Wei. And the other person behind the scenes, whom you can see actually sitting on his gaming chair, is Vice President of the UiTM Moot Club, Mr. Des Azimi Sufyan. Hello, Des. Thank you so much.
Des, you are live.
Yeah, you are live now, Des. Yeah, he refuses to say anything. But maybe when we reach 1 million subscribers, there will be a voice reveal by Des. Okay.
All right.
So anyway, thank you so much, Miza. Thank you, Des. Thank you, Wei Wei. Thank you to all the attendees. I wish we could know you better and not just have to refer to you as anonymous, except for Anis and Imran. Thank you for dropping by, and have a nice day.
Bye.
Goodbye.